The Supreme Court has dismissed an injunction application filed against the approval process of the new ministers vetted by Parliament. The application filed by South Dai MP Roxanne Nelson Dafiamepo was subsequent to a substantive application seeking to get Parliament to vet old ministers and deputy ministers who were reassigned without going through the approval process. But the Apex Court on Wednesday dismissed the injunction application, stating that the approval process of new ministers and deputy ministers has no correlation with the reassignment of old ministers and deputy ministers.
Prior to the hearing of the case, the National Democratic Congress, on whose ticket the applicant is a legislator, raised issues about the Apex Court's scheduling of what they described as politically affiliated cases. They pondered why the Chief Justice will schedule a hearing of the case on the Ministerial Appointments ahead of the application against the anti-LGBTQ bill, considering the latter was filed 2 weeks before the former. But Attorney General Godfrey Yeboah-Dame noted that the concerns are baseless. He clarified that it was at his request that the instant case was heard earlier.
The duty to fix the date for hearing rests in the registry of the Supreme Court. And I do not understand where this business of people actually scrutinizing when applications are faced for hearing or why these applications are faced for hearing even came from. Back in the days, if we file an application in the Supreme Court of Ghana, it takes even 3 months for you to have a date for hearing. It is only after a party has made an application for an expeditious determination of the process that the matter will come up for hearing. And indeed, in the record, we show that this particular case, for the record, it must be indicated that I specifically applied for an expeditious determination of the matter. I applied for an expedited hearing of the application.
But in court on Wednesday, the applicant, Roxanne Nelson Dafiamepo, and his counsel were absent. It then emerged the lawyers of the South Dai MP refused service of processes of the court, including the notice of hearing and the affidavit in opposition to the interlocutory injunction filed by the Attorney General. The bench, chaired by the Chief Justice Gertrude Isaba Tokonu, in an attempt to understand reasons for the absence of the plaintiff and his lawyer, received information that the counsel on record, Niek Bakposoma Ado, caused for the refusal of service of the notice of hearing. This prompted a decision for the bailiff to be queried under oath on what transpired when he attempted to serve the processes. The bailiff testified that a staff of the law firm of the plaintiff's lawyer relayed information that processes from the court are not to be received based on a directive from Niek Bakposoma Ado. The bailiff further testified that he left the notice of hearing and the Attorney General's affidavit in opposition to the application for an interlocutory injunction on the decks of the said staff after he was provided with the information. The Attorney General, who believed the process amounted to service regardless, described the actions of the plaintiff's lawyers as disrespectful.
It's really, for me, gross professional misconduct. Be as it may, the court proceeded to deal with the matter, and that is it. I think that was very unfortunate, especially as the same counsel was in the same day filing processes in the Supreme Court of Ghana. Earlier in the morning, he was rejecting processes from the Supreme Court of Ghana, and then in the afternoon proceeded to file processes in the same Supreme Court of Ghana. And I think the process of the highest court of
the Apex Court, after satisfying itself that the processes were duly filed, despite the correspondence between the bailiff and the staff of Niek Bakposoma Ado, allowed for the injunction application to be moved. Both legal representatives of the Speaker of Parliament and the Attorney General, who are the defendants in the case, opposed the application. The court, after considering the arguments and all processes filed, unanimously dismissed the injunction application. Attorney General Godfrey Yeboah-Dame, after proceedings, stressed on the need for Parliament to continue with the approval process.
On record in Parliament is a letter that I wrote to the Speaker asking him to reconsider the decision and all. So I expect Parliament, after having come to the Supreme Court to oppose this application, to also reconvene and deal with the matter relating to the approval of the ministers. There's nothing at all that impedes or inhibits Parliament from doing its work. They ought to do their work. And I think that the adjournment of proceedings was most unjustified.
With the injunction application dismissed, what it means is that Parliament will not have to take steps to approve the minister-designates and deputy minister-designates that have been duly vetted, or disapprove of them if the appointments committee so determines. Reporting for Citi News, Hansen Ajeman.